Now, you might assume that if a medical director makes a critical mistake in a nursing home, it's their responsibility. And the nursing home, well, they're free and clear. But what most families don't realize is that Missouri nursing homes can also be held accountable for the negligent conduct of a medical director. My name's David Terry. I'm a nursing home abuse and neglect lawyer, and I've handled multiple cases where the facilities try to deflect blame to the medical director when they too had at least a share of the blame. This video will help you understand the relationship between a nursing home and the medical director, and when the facility can be held responsible for the negligent conduct of the medical director. It's important that you understand the dynamic between the facility and the medical director if something goes wrong while your loved one's there. So let's get right to the heart of today's topic: medical director negligence, and when the actual nursing home facility, not just the individual doctor, can be held responsible under Missouri law. But before we look at legal responsibility, let's talk about what exactly the medical director is. The medical director in a nursing home is typically the physician who oversees medical care for all the residents. While their level of responsibility may differ by facility, typically it's the medical director's job to review resident care, to give orders for resident care, oversee the overall care for the residents, to be on call, and to timely respond to calls from the facility. They're also supposed to make sure that the staff are following correct procedures. But sometimes things go wrong. The medical director might fail to act in a timely manner when the facility calls about a serious infection, or perhaps she prescribes the wrong medication or the wrong dosage. Maybe they overlook the medication error of the facility or ignores reports from the facility staff about bad things happening there. Let me give you an example. Let's say that a family noticed that their mother, who was a resident at a St. Charles County nursing home, was losing weight rapidly and developing bedsores. Despite repeated complaints by the family to the nurses and even the medical director, nothing changed. The sores worsened and became infected. Fed up with a lack of action, the family has an outside physician intervene, resulting in proper orders and proper care finally being provided. Is this medical director negligence? I'd say so. But is it also facility negligence? Well, let's look at that. So you see, in this situation, I think there's shared negligence between the two. But here's a key issue. The medical director's not in the facility 24/7, nowhere close to that. The nursing home is the eyes and ears of the doctor. So what if the nursing home was not timely giving information to the physician? Now that changes the analysis, doesn't it? So now the question is, when can the facility itself, not just the medical director, be held legally responsible for this kind of negligence? So let's break that down. The first way a facility can be legally responsible is through direct liability. Now, this means that the facility itself did something wrong that led to harm. It's possible that the nursing home hired a medical director who wasn't actually qualified for the job. Frankly, while it's possible, I think it's rare. I've taken deposition of many medical directors over the years, and while I believe some of them were borderline incompetent, I have not seen any who on paper were not qualified. So that is not a likely issue for us if we want to pursue direct negligence against the facility, at least in that capacity. More likely is the fact that the facility failed to properly train their staff or didn't even have enough staff members on duty, leaving all the residents at risk. Staffing and training are key issues. For example, Missouri state regulatory rules require nursing homes to maintain a sufficient number of staff members to meet the needs of the residents in their facility and to properly train their staff members. They have to ensure that staff members are competent to do the job that is required to meet the needs of the residents in the facility. They're also required to train their staff on how to recognize neglect or abuse and to report it. They are mandatory reporters. But look, that's a discussion for another time. I'll do a video on mandatory reporters in the future, but spoiler alert, they rarely report themselves. But let's go back to our issue here. If the facility fails to inform the medical director of key information he or she needs to know about a resident's medical condition, that can create direct liability on the facility. The medical director could say, hey, I didn't know. Likewise, if the facility fails to provide timely, accurate, and complete information that causes the medical director to make a harmful decision, there's a good argument that the facility can be directly liable for any harm that results out of that. The second way a facility can be held liable for the actions of the medical director is through vicarious liability, which is just a fancy way of saying that the company is responsible for what its employees do as long as they're doing their job. So here's how that works in Missouri. If the medical director is an actual employee of the nursing home and the harm happened while they were working in that official role, the facility can be on the hook for their mistakes. For vicarious liability to be viable, the employee needs to be acting within the scope of their employment. That's the key phrase, at the time of the negligent act. Here's an example of this. Imagine a medical director is on the facility's payroll, and that medical director misinterprets a resident's condition, and as a result, the resident is given the wrong drug and ends up in the hospital. In this situation, the medical director was acting within the scope of their job duties, and under Missouri law, the facility could be held legally responsible for his actions. But I know from having been handling nursing home cases in Missouri for nearly 25 years, it is extremely rare for a medical director to be an employee of the nursing home. Typically, they're what's called independent contractors, not direct employees. Now, this can make things a little bit more complicated, and that brings us to our next point. Many Missouri nursing homes will try to protect themselves by hiring medical directors as independent contractors instead of employees. Now, why do they do this? Maybe it's because the facility thinks that this shields them from lawsuits if the medical director makes a mistake. Nursing homes in Missouri have a duty to supervise not just their nurses and aides, but also any independent contractor in the building, and that includes the medical director. It also includes agency staff, which are extra nurses and CNAs brought in to cover shifts when the facility is short-staffed. So here's what this could look like. Suppose the medical director routinely makes medication errors and ignores staff reports about resident needs. If the facility's top management turns a blind eye to these problems or actively discourages staff from speaking up, then the facility can absolutely be held responsible individually or in concert with the doctor. Missouri law expects nursing homes to have systems in place for reporting, investigating, and correcting problems, including those caused by the medical director. For example, let's talk about a case where facility nurses repeatedly reported concerns to the administrator about the physician not responding to questions that resulted in delayed medical care. The complaints were timely made to the administrator, but nothing was done. Then a resident died due to untreated sepsis because antibiotics were not timely ordered due to the medical director's failure to timely respond. Now, in that lawsuit, the nursing home's going to point the finger at the medical director. And they're right, but the facility is also on the hook for significant legal consequences for failing to supervise and take action when they knew their independent contractor was negligent, was not responding. So the bottom line here is this: if a facility in Missouri fails to monitor, fails to supervise, or fails to correct deficient conduct by the medical director, their independent contractor, they can be sued for the harm that results. Let's talk about the practical side here. What if you're a family member watching this and you suspect the facility or the medical director is responsible for a loved one's harm? The answer is that's going to be a decision by your lawyer because each situation is unique. But there are some steps that you can take that will be an enormous help for your lawyer. Let me go through these. Step 1, document everything. Keep a detailed log of what you see and what you hear and include the dates, the names, and the exact problems. That's critical. Step 2, photograph and video every concern you have with your loved one's health. If cleanliness is a concern, photograph and videotape those areas of concern. If they have a bedsore, definitely get photographs. If the facility is providing the wrong food for their diet, take pictures. If short staffing is a concern, you can also photograph empty hallways. But I have a word of warning here for you. Do not photograph employees or other staff members. This violates privacy laws and it could undermine your case. Step 3. File complaints with the facility and its home office. You can report your concerns to the facility and its home office, but always make those reports in writing. Get documentation that your complaint was received and always keep a copy of your complaint. I promise you, if you do neither of those things, the nursing home will never admit that you filed a complaint. Step 4. File complaints with the state. You can and should report serious concerns to the Missouri Department of Health and Senior Services. Step 5. Request records. Missouri law allows you to request copies of medical records for your loved one. Now, for a living resident, the power of attorney has the power to request those records. For a deceased resident, those eligible to collect the records are those within what's called the class of wrongful death claimants, or it can also be the personal representative of the estate. Now, this can get a little bit complicated, so I've made another video about that to provide you with the guidance that you need on that issue. Step 6, consult an attorney. These cases can be complex. They almost always are complex, especially when facilities try to shift the blame to the medical director or to somebody else. An experienced Missouri nursing home abuse attorney can help you determine if you have a legal case. Now, I know that families often feel overwhelmed and intimidated by the legal process. I get that. When my dad was in a nursing home, I learned firsthand how overwhelming that these issues can be. But don't let that stop you from doing the things that you can do to protect your loved one. So why does all this matter? I know that it's easy to get lost in the details. I know that it's easy to forget why this matters. But here's my take on it. Ultimately, holding nursing homes responsible isn't just about compensation. It's about keeping Missouri's most vulnerable residents safe. If nursing home companies know that they can't escape legal responsibility by blaming the medical director or anybody else, they're more liable to fix bad practices and improve patient care. In recent years, lawyers like me have filed multiple lawsuits against the nursing home industry here in Missouri, and that has led to positive changes in Missouri nursing homes. We've made some progress, but we have an enormously long way to go. And when family members like you refuse to be bullied or ignored, and you take a stand, you're not just helping your own loved one, you're helping to protect others as well. So thank you so much for watching today. If you'd like to learn more, click the first link in the description. And if you found this video helpful, please remember to like and subscribe. I'll see you over there.